From the News Channel 5 Network, this is OpenLine.
Hello, everyone. Welcome to OpenLine. I am Ben Hall. Good show tonight on Wednesday night. We are talking about an issue that is before the United States Supreme Court. Should same-sex marriage be legal in all 50 states? This decision will likely come down in June, and we want to talk about what are some of the issues at play here and really hear from you, but also from people who are well informed on the issue. We have people from both sides of the issue here. Let me introduce them. Happy to have them both. Chris Sanders with the Tennessee Equality Project. Chris, thank you for being with us.
Thank you for having me.
And David Fowler with the Family Action Council of Tennessee. Thank you for being with us.
Good to be with you.
You've both been with us before, and I appreciate you both coming on again. I want to hear from both of you off top here, but essentially get a sense of the case itself that is now in front of the Supreme Court that the justices have heard and they will be ruling on, we believe, in June. And then what maybe the main issue is as far as each of you is concerned. But what is the case that is really at play here?
There are a number of cases that have been brought by the states, Ohio, Tennessee, Kentucky, and Michigan, a variety of plaintiffs with different situations. There are marriage bans. I think in all those cases there are state constitutional amendments. Certainly there are statutes, and in many cases there are constitutional amendments that define marriage as the union of one man and one woman. There are plaintiffs who are coming forward with different life situations. Some want to adopt each other's children. Some want a marriage that has taken place legally in another jurisdiction to be recognized in their home state. Others had to move to a state like Tennessee for a job. They had no choice, and suddenly their marriage legally doesn't exist in the same way that it did or at all in another state. So in one case in Ohio, the plaintiffs were a couple, and one of them died, and it's about a death certificate having the other partner's name on the death certificate. So a variety of issues are presented in these cases.
And again, it's about should same-sex marriage be legal in all 50 states? And so there are some of the personal plaintiff issues. What are the issues that you're focused on here?
Well, there are two legal issues, and the court set what those were. The first, to put it in sort of a layman's vernacular, is it unconstitutional to define marriage as just a man and a woman, or is it, another way of saying it, is it constitutionally required to define it some other way? Then the second question is one under the full faith and credit clause type of thing, that are states required to recognize a marriage in another state that's contrary to the policy of their own state? Right. And those are the two questions, and depending on how the first one's answered, you may not need to answer the second question. So if the court says, no, you can't limit marriage to a man and a woman, you have to define it some other way, then obviously every state would have to recognize that. So
the polls have indicated we're moving in that direction. I believe 36 states recognize same-sex marriage. If that is the case, would it, I mean, where do you, you're obviously opposed to this. In Tennessee, we do not recognize same-sex marriage.
That's right.
Do you think this is inevitable? And so, you know, what do you expect when the court rules in June? And I asked you that, David.
Well, there's a couple of questions you've asked there. One, is it inevitable? One is, what do I expect, which is a different question. And of the, I think is it 37 states that actually recognize same-sex?
I think so, and then of course DC as well.
Yeah, so the 37, but of those, only 11 have actually voted in some way through the people or legislative bodies to do it. The other 26 have all been as a result of a court decision. Right. So when you talk about the inevitableness about it, the reality is 31 states had voted to define marriage as a man and a woman, and only 11 have actually taken some action by the people / their representatives to change that. So in terms of the inevitability, I would say no, nothing's inevitable. In terms of what I expect from the court, I really don't know. I can, having been a lawyer, well, I still am. Technically, I try to hide it as often as I can, but I went through something called moot court, which you argued one side, and then you went in another courtroom and you argued the other. And certainly there is language in the Windsor opinion that was the case 2 years ago, striking down the Defense of Marriage Act at the federal level, that would signal that, well, we're going to have same-sex marriage. But there were also comments and questions asked by Justice Kennedy in particular, and even Justice Breyer during the oral arguments, that to me would give pause to say, well, maybe they aren't ready to go that far yet. So I'm probably not going to be shocked either way it comes out, but I do think it'll be 5-4, and my guess is Kennedy will be the deciding vote.
He's been the deciding vote on some of these other major rulings. I'll ask you the same two questions. Is it inevitable? How do you think the court will rule?
I think we'll get a 5-4 decision striking down marriage bans. Could go a little higher. Justice Roberts very intriguingly talked about a sex discrimination angle. It could be that you have 5 or 6 on one side, but they write a bunch of separate opinions and don't come up with a common rationale for their decision, or a variety of rationales. I don't know. Inevitable, I think people make things happen. I don't think things are just inevitable in and of themselves. I do think, however, the implications of the 14th Amendment are that not so much paving a path for marriage equality specifically, but they are inevitably a check on state power. I think there are a lot of people in our state who read the amendments to the U.S. Constitution 1 through 10 and kind of stop there. But we have a 14th Amendment that limits the power of state governments. And it takes a long time in the legal process for certain things to be recognized as unacceptable according to the 14th Amendment. But I think we're reaching a point of inevitability of interpretation where marriage bans are just not seen as compatible with what the 14th Amendment says about what states can and can't do.
Sometimes with these issues we hear it's a states issue. Do you feel that way? Is that one of the arguments here, that we should leave it up to the individual states? We have 37 states have made a decision. Tennessee is one of the states that has made a different decision. Do you think that's one of the arguments, and is that something that you would argue, that this is a state issue?
Well, I would, and let me just comment. In terms of the 14th Amendment, what it says is that you have to have equal protection of the law, and then it says you can't deny a person the right to life, liberty, or property without due process of law, which is a procedural thing. And oftentimes that concept of, we deprive people of liberty all the time. We call them criminal laws. But they're enacted through a process where everybody has an opportunity to participate, and so to me, there's some fundamental issues we need to think about in our country in terms of injecting into the due process clause things we like, and because Chris may like same-sex marriage under there, but he's not going to like some other thing under there, and so that's where I kind of say, look, we can have this policy discussion at the state level, but from a constitutional standpoint, and there are 3 legal tests, if I can, without getting into the debate. The first thing is the courts have said, unless we're dealing with a fundamental right, really, or a suspect class of people, like race is a suspect class because of the 13th and 14th Amendment, then the legislative bodies only have to have a rational basis. Could a reasonable person think, okay, this law reasonably accomplishes a reasonable thing? And that's the constitutional question. And so when you ask me that question, I would say that, well, is marriage really a fundamental right? And there are profound implications from that. If it is, then can I change ages? Can I prevent incestuous marriages? If you have a fundamental right to something, you have a fundamental right to it. We don't have a suspect class here, according to the courts in the past. So it comes down to, could a reasonable person think that this accomplishes a reasonable goal? And that's sort of what was happening in the oral arguments. Justice Kennedy saying, for thousands of years across the globe in all kinds of cultures, before law, after law, cultures that embraced homosexuality, those that didn't, people thought marriage was a man and a woman, and are we going to sit here and say that for thousands of years they've all been unreasonable and irrational? And
that was the question asked by Justice Kennedy that kind of gave people
some hope
on your side,
that he would say, we can have an honest debate. And people may agree more with Chris, they may agree more with me, but let's let that work itself through the normal democratic process rather than make it a constitutional thing. And whether this is marriage or not, my philosophy, and I hate to be hogging the show here a little bit, is be careful what you write into the Constitution, because you can't fix that. You know, it's hard to amend the Constitution at a state level, at a federal level, so be careful what you write into it, because you may not like the precedent.
Well, and we have to go to break, but I want you to respond to that just a minute or so. I mean, what do you think about what he said?
I think we may end up having suspect class as part of the argument if we go with Robert's line of inquiry about sex, and sexual orientation may soon become viewed as a suspect class at the federal level. We'll see. And of course, marriage has changed a great deal, but the opinions of the courts, certainly Loving versus Virginia and so forth, you begin to see marriage as a fundamental right. So I would view these things slightly differently. I'm not an attorney, but I think you can make arguments on the other side that certainly it's fundamental and we may be dealing with a suspect class. I would suggest we are.
And when Justice Kennedy said, how in the last 10 years are we going to know what's appropriate based on, you know, and it's been different for a millennial prior to that. And of course, I haven't said that properly.
We can talk about the history of marriage after the break if you like.
Okay, that was his question, and that really made people think about some stuff. All right, so we'll take a break. If you want to call, there's the number, 615-737-PLUS, 615-737-7587. If you want to call, you're on the line, hold on. We'll get to your call. Be back right after this.